In today's video, we'll discuss the default settings of farm succession. What happens if you fail to plan? And how does the law provide a plan for you? Before we get started, I do want to clarify that this presentation is for educational purposes only, and it will provide only general information, not specific legal advice. What happens if you do nothing? As I mentioned, state law provides a plan for those who have no plan. Today we'll talk about intestacy, probate, estate tax, and long-term care and retirement planning, the 4 items that I term the default settings and the legal risks of failing to plan. I encourage you to think about these risks and how you would feel if they were applied to your own situation. Feel free to pause as we go through and do an analysis of how this would impact you. The first issue we'll discuss is intestacy, or intestate distribution. State law provides default distribution rules for your assets. If you have no estate plan, whether that's a will, a trust, or some other tool, state law is going to decide who will receive your assets and in what proportions. In Wisconsin, of course, we'll have to think not only about marital property, but also have to think about the relationships with spouses, children, and other family members. And like I said, the law will decide who receives what assets and in what amounts. Not only will state law decide who receives your assets upon your death, but it will also provide a court process for distributing those assets, called probate. In the probate process, someone will be responsible for inventorying all of your assets, paying creditors, and distributing the remaining property to those heirs and beneficiaries, like I mentioned, as were decided under intestate distribution. Now, just because you create a will doesn't necessarily mean you won't still have to go through probate. So listen up and pay attention. Probate has a number of characteristics, but one of the most commonly talked about items is the probate fee. In Wisconsin, the probate fee is 0.2% of the value of property that has to go through the probate administration process. What does 0.2% look like? Well, we'll use sort of a general, very basic estate for all of our examples today. In each instance, you'll want to know what is in your estate. What is all of the property that you own? In this example, our estate has $10,000 in a bank account with a payable on death designation, $250,000 of farm equipment, and $3 million of land. Now, what's important to mention here is the POD designation means that that bank account will not have to go through probate. That means that we're only looking at the $3.25 million of the estate that's subject to probate, multiplying it by the 0.2% fee, and we're coming up with a court fee of $6,500. Now, the probate fee is often confused with estate tax, which we'll talk about a little bit later on, but just make a note that the probate fee and the estate tax are 2 separate items that might apply. Along with the probate fee, there are several other characteristics of probate to consider. Along with the probate fee, you want to think about attorney's fees, bond costs, appraisal and valuation fees, accounting fees, and publication fees that may all be required with that process, potentially bringing the cost to more than just that 0.2% of the value of the property subject to administration. Probate is also a public record process, meaning that anyone could go down to the courthouse and pull up those documents to see what assets are passing through probate, what they've been valued at, and who receives them. Some folks are not a fan of this, particularly if they don't want one heir to see that another heir is receiving more or less or a certain asset. Another thing to keep in mind with probate is that this normally is going to take 6 or more months, during which time the personal representative is in charge of those assets. From a farm perspective, this can be challenging because it might overlap with a growing season, and the individual who is appointed might not be willing or able to allow the farm heir to use those assets during that time. If you have created an estate plan that goes through probate, you will probably have selected your personal representative. But again, if we're thinking of a situation where you've done no planning, the court is instead going to be responsible for choosing that personal representative, and you may or may not like who they choose. The next issue we'll talk about today is estate tax. Like I mentioned, this is different than the probate fee. Wisconsin does not have a state-level estate tax, but our residents are still subject to the federal estate tax. The federal estate tax ranges from 18 to 40%, but it doesn't kick in until you've used your lifetime unified estate and gift tax credit. In 2025, individuals have a credit that is worth $13.99 million. Meaning that an individual who dies in 2025 will be able to pass on $13.99 million of assets before any estate tax would be owed. Keep in mind that this is set to expire in 2026 and return to about $6.98 million, and that number is, of course, adjusted for inflation annually. But sort of the key here is that as we look at estate value and compare your net worth to see if estate tax is an issue that you should be worried about, you'll want to keep not only the $13.99 million number for 2025 in mind, but also the future $6.98 million number. This does change from time to time with congressional action, and the upcoming administration has expressed an interest in maintaining that higher level, but for now we will want to plan for the decrease until we learn otherwise. So let's see an example quickly of how this would work. Going back to our same estate from before, $10,000 in a bank account, $250,000 of farm equipment, and $3 million of land. Now, with probate, the payable on death designation removed that bank account from the probate process. So it wasn't part of the total value and you weren't paying a fee on it. However, it is part of the estate, so it's included in the estate value for estate tax purposes. Totaling those together, we get $3.26 million. But that's below the exemption of $13.99 million. So if this individual died in 2025, they would not have estate tax due. Now, we're going to make this a couple times trickier. I think we'll start with the bullet on the bottom first, which is portability or the deceased spouse unused exclusion. What this means is that if you are married, you may be able to use your spouse's exemption. So each one of you has a $13.99 million exemption in 2025 or a $6.98 million exemption in 2026, and then of course adjusted for inflation moving forward. Collectively, you can pass the sum of both of your exemptions on without any estate tax being due. So if you are a married couple who both pass away in 2025, you would be able to pass $27.98 million collectively before any estate tax is due. So if your net worth is under that $27.98 million, it's not going to be an issue in 2025. If we are looking at 2026, same situation, we're going to look at a $13.96 million exclusion for you and your spouse. And so if your net worth is less than that $13.96 million value, you're not going to have estate tax due. Keep in mind, however, that you can reduce your unified estate and gift tax credit with lifetime gifts. Each year, you are allowed to pass a set dollar amount to individual recipients before it starts to impact your credit. So in 2025, that number is $19,000 per recipient. I can give you $19,000. I can give my brother $19,000. I can give my friend Emily $19,000. And I don't have any impact on my estate tax credit. However, once I cross that number, once I give $19,001, that extra $1 per recipient is going to reduce or count against my unified estate and gift tax credit. So for example, if I give $100,000 to my friend Emily, I am now going to have $81,000 that was more than my annual exclusion, and I'm going to have to subtract $81,000 from my unified estate and gift tax credit, meaning I can give that much less when I pass away. We'll go through an example of what this looks like. So we're back to our estate, but we've increased the values a little bit. We've got a $100,000 bank account with a payable on death designation, $1.25 million of farm equipment, and $6 million of land. If we total those together, and again, remember these are all of the assets that we own, our net worth and our estate value is $7.35 million, which is below the exemption of $13.99 million. So there's no tax if you pass away in 2025. However, it's above the exemption of $6.98 million. So it is possible there would be estate tax due if this individual passed away in 2026 or later. That is, of course, assuming that they are unmarried and don't have any portability from a spouse who predeceased them. When we're thinking about estate tax, what you want to do is think about what your net worth is. And the key here is at fair market value. So what would this sell for if I were selling it on the open market? Figure out your net worth, asking that question, and then of course compare it to the exemption amounts. Again, thinking about $6.98 million or $13.99 million if you are single and don't have any portability. Or if you are married, you may want to think about that with that $27.98 million number or the $13.96 million number. Finally, I want to touch on long-term care and retirement planning. Again, today we're talking about the defaults of failing to plan. So if you have failed to plan, that means that you may need to use your income and assets to fund your retirement and long-term care. Medicaid, which is the government assistance for paying for nursing home care, is only going to kick in when you are impoverished. So it may not provide the standard of living that you're hoping for, and it might take a couple of years before you're actually able to access that assistance, meaning you may need to use your assets to fund it in the meantime. If that's not something that's appealing to you, you might want to think about long-term care insurance, or if you are in a situation where you suspect that whether from a current health condition or future health condition, you may need significant long-term care, it may be valuable to speak with an attorney and start that planning process now. Now, if you're feeling overwhelmed about the defaults, don't worry, you're not alone. It is challenging to get started on farm succession and estate planning. Studies show that people feel intimidated by lawyers or have a hard time assessing their worth by really putting together that net worth number. Some individuals aren't comfortable talking about money or even the fact that they themselves might die someday. And finally, two issues that we see pretty regularly with farm succession are that some individuals have a hard time making the hard decisions that an estate plan requires on who is going to get which assets. Unfortunately, an attorney can't tell you who should get what, which means that you ultimately have to make that hard decision. That might also mean coming to grips with your true feelings about family beneficiaries, whether that's the son-in-law that you really don't like, or the daughter that has a gambling problem, or some other family member who might be dealing with addiction or spending challenges. These are heavy conversations, but the risks of intestacy, probate, estate tax, and long-term care are real risks. Use this information to think about how you feel about intestate distribution, letting state law decide who will receive your assets, the probate process, along with its fees and the time that it takes, estate tax and whether that's going to be an issue for you, and of course, long-term care and what you're hoping your future looks like. Thank you for getting started by learning about the defaults. Without learning about the defaults, it's hard to know what changes you're interested in making as you put together your farm succession and estate plan.